Welcome to the first of the three lectures on the judicial branch in U.S. government. As you know, judicial branch is one of the three main branches of the U.S. government, along with legislative branch that creates laws and the executive branch that executes the laws or runs the government. Judicial branch is in charge of interpreting the laws in the United States. For us to properly understand the role played by the judicial branch, we need to first have some background information on the U.S. law. In the United States, there are two main types of cases: those that fall under criminal law and those that fall under civil law. Criminal law refers to the issues when one party breaks the law one way or another, and accordingly, one of the two parties in this type of lawsuits is the state. The prosecutor, representing the people, prosecutes and charges an individual or a business with some violation of the law. Burglary or gun violence would be examples of this type of law, since both are illegalized in our legal system. Civil law, on the other side, deals with any kind of disputes, civil disputes or social disputes, you might say, without necessarily a violation of the law. So here, two parties are in some sort of a disagreement, and neither party is necessarily breaking the law, but the dispute, the disagreement is there. It's real. So disputes between neighbors might be an example, could be an example of this type of law. Here, what we need to understand is that the dispute that's subject to this type of lawsuit has to be a justiciable dispute, which means that it needs to be resolvable by a court of law somehow. In other words, one party saying that the other party hurt his or her feelings, for example, as a result of some sort of an action, would not be considered as a justiciable issue, and accordingly, no court would agree to hear such a case. A good way of understanding the difference between criminal law and civil law is the O.J. Simpson case. Back in the early 1990s, O.J. Simpson was a very famous retired football star, and he was accused of murdering his ex-wife and a friend of hers in her LA house. And in the criminal lawsuit, he was exonerated after a trial that took nearly a full year. He was found not guilty. But in the following civil lawsuit charged against or filed against him by the families of the gentleman who was murdered in the subject case, he was found guilty, and he was made to pay $12.6 million to the children of Nicole Brown, Mr. Simpson's ex-wife, and $33.5 million to the families of both victims. O.J. Simpson case is considered to be one of the best known trials in the U.S. history. So I suggest you learn about this case, the details of it, and as it provides a great learning lesson for different types of law in our system. Are these actors plaintiffs? So here in this slide, I'm sharing some terminology with you. Plaintiff refers to the accuser in a lawsuit. Defendant refers to the accused party in the lawsuit. Grand jury is the jury that's held first in a trial that consists of ordinary citizens that are chosen to simply comment on whether or not there are merits for an actual trial to be held. So they do not comment on the accused person's or the defendant's guilt. They just simply comment on whether or not the plaintiff or the state, the prosecutor, really does have enough evidence that point to the person's possibility of guilt. So therefore, they say, yes, there should be a trial on this issue, or no. On the other side, trial jury is a different set of citizens. They are also ordinary citizens. They don't have to, they're just chosen by the trial system by use of computer selection. And they're supposed to be the peers of the defendant, according to the U.S. Constitution, which means that they should represent or they should resemble various aspects of the defendant in terms of income level, education level, etc., in order to mitigate the possibility of various biases one might have against the defendant. And trial jury's main job is to comment on the guilt of the accused person or the defendant. Trial jury is the final sayer in these lawsuits. Lastly, friends of the court is another term you should be aware of. Amicus curiae is the Latin term used for this, and this is basically the opinion paper written by an outside expert or a group of experts who are external to the trial. They're not a party to the trial, but they are experts in that field, and they simply provide some useful information for the court to review about the issue. This is called the Friends of the Court briefs, or amicus curiae briefs. In the United States, currently there are 1.3 million lawyers working, and Legal Service Corporation is a company that provides free attorney services to defendants. It's also known as legal aid, and they take so-called pro bono cases, which means that the accused person does not pay any money to this company for the company to provide a lawyer to the person to defend himself. Or in some cases, according to the contract signed by the two party, there may be some money involved, but that would be conditional upon the plaintiff winning some money as a result of the lawsuit, and then he shares some part of those proceedings with those money with the pro bono lawyer or his or her company. The idea that every accused person must be provided a free attorney by the state is a right that was created upon the initiative of an ordinary citizen back in the 1960s. In 1961, a gentleman by the name Clarence Gideon was charged by the state for some petty theft in the state of Florida. So when he went to the court, at the time the laws were such that only capital punishment or capital cases, major crimes, forced or required the state to provide attorney to the accused people. But Mr. Gideon wrote a handwritten note and sent it to the Supreme Court saying that he is not an educated person, but he does not understand why or how a government authority can charge a person with a crime, and then if that person doesn't have any money to hire a lawyer, he has no way of defending himself. And this doesn't sound fair to me. I'm not knowledgeable about laws, but this doesn't sound right. Could you please fix this? Basically, this was the essence of the letter, and it came to the Supreme Court, and the Supreme Court agreed to hear his case, and eventually they ended up creating the right to an attorney as a legal right that belongs to every citizen and resident in the United States. This was a landmark Supreme Court case. Please check out the video below to explore this important lawsuit further. In the video, Mr. Gideon's significance for the U.S. legal system has been discussed. When we look at the federal judicial system, we see that there are courts in 3 different levels. At the lowest level, there are district courts, 94 of them to be exact, and they are typically the first place where a federal trial is held. Then above the district courts, there are 13 appeals courts or appellate courts, and so they deal with the appeals that come from the district courts. And up top, there's one U.S. Supreme Court, and this court deals with various reviews of constitutional matters in the country. So starting from the lowest level courts, the district courts, these courts try federal crimes because they're federal courts, and civil lawsuits under the federal law and across state lines. So if there's a crime that involves more than one state, then federal district courts deal with them. They also supervise bankruptcy and naturalization cases. So if any of you is a naturalized U.S. citizen, then the court where you were officially made a U.S. citizen was a federal district court. And lastly, district courts review some federal agencies as well to make sure that their work is done in a legal and constitutional fashion. Appellate courts are the appeals courts. So when a case is successfully appealed from a lower level court, district court, then these courts deal with them. They only focus on the errors in procedure and law. So there's no trials held in these courts, or no testimonies are heard by the judges. It's simply a collection of judges reviewing the paperwork from the earlier court's case to see if there are any errors in the procedure, and if the earlier court made any errors in this type of legal procedures that violated some sort of rights of the defendant and served injustice. If so, they review the case and they can overturn the lower court's decision. There are 12 circuit courts and 1 U.S. Court of Appeals for the federal circuit, so a total of 13 appellate courts. We will discuss Supreme Courts in the next segment, since it's quite significant for us, and there's not enough time left in this one. So I will continue with another important position in our legal system that we need to know, and that position is Solicitor General. Solicitor General is a Department of Justice official appointed by the President. His job is to decide whether or not to appeal in a case that the government lost in the earlier court, in the lower court. And his main job is to defend the U.S. government before the U.S. Supreme Court. Solicitor General argues before the Supreme Court so often that he also has an office in the Supreme Court building, in addition to an office in the Department of Justice building. And Solicitor General is lightheartedly called to be the 10th justice in the U.S. Supreme Court because of the fact that this person argues so often in the Supreme Court. Oftentimes, Solicitor Generals end up becoming a member of the U.S. Supreme Court as well as justice. Currently, Noel Francisco is the U.S. Solicitor General, and he's a first-generation Filipino-American from the city of New York. This wraps up the first of the 3 lectures on the judicial branch in U.S. government.